Members, it's the appointed time. We have a quorum. I call to order this meeting of the panel on administration of justice and legal services. Since the last meeting, the Secretariat hasn't issued any information paper. Items for discussion at the next meeting. There are two papers. They are LC paper number CB bracket 4334/2024 bracket 01. It is the list of outstanding items for discussion. The other one is LC paper number CB bracket 4334/2024 bracket 02. It is a list of follow-up actions. At 4:30 p.m. on the 22nd of April, we will hold the next regular meeting. We will discuss the two items suggested by the administration. They are, first, strengthening the regulatory system on the accreditation and disciplinary matters of the mediation profession, and second, progress of DOJ's work in taking forward the construction of rule of law in the Greater Bay Area. Agenda item 3, Law Reform Commission Secretariat, progress on the systematic review of statutory laws of Hong Kong. This is our item for discussion today. Let me first invite the relevant representatives into the meeting room. There are two papers under this item. LC paper number CB bracket 4334/2024 bracket 03. This is the paper provided by the Law Reform Commission Secretariat. The other one is LC paper number CB bracket 4334/2024 bracket 04. This is a background brief prepared by the Legislative Council Secretariat. Welcome, Secretary for Justice and his team. I also welcome representatives from the Hong Kong Bar Association. Let me first welcome Chairman of the Law Reform Commission of Hong Kong. Sorry. Right. Secretary for Justice, in the capacity of the Chairman of the Law Reform Commission, will walk us through the paper. Mr. Paul Lam. Thank you, Chairman. I'd like to thank the panel for giving me this opportunity to report to you the work of the Law Reform Commission Secretariat. That is the progress on the systematic review of statutory laws of Hong Kong. I will mainly focus on the adaptation of laws today. That is the latest progress of our work in this regard. We have to move with the times, and we have to ensure our status is in line with the framework under the One Country, Two Systems. The LRC Secretariat has been conducting systematic review of statutory laws of Hong Kong. This consists of three areas: adaptation of laws, consolidation of laws, and repeal of obsolete laws. Last year, in July, the Secretariat made a report on its latest progress, and since then we have achieved further progress. We have to thank the relevant bureau for introducing legislative amendment bills, and with your support, we have been able to make progress. Apart from paragraph 7A of the paper, that is, we have enacted proposed adaptation provisions for two pieces of legislation. The Safeguarding National Security Bill has just been passed by the Legislative Council. After prudent scrutiny of the bill was passed last week and took into effect. For legislations of which adaptation provisions have been enacted, we have seen 7 more of them. The Secretariat has been working with the relevant bureaus, and we have also been working with the relevant legal divisions of the DOJ. We have examined 101 pieces of legislations and subsidiary legislations. Compared to last July, we have seen more of them, 7 more of them. That means we have found more legislations for which adaptation provisions have to be enacted. We will identify more legislations and subsidiary legislations for which adaptation provisions have to be enacted. The SAR government attaches a lot of importance to the adaptation of laws, and we will issue relevant drafting instructions as soon as possible, as mentioned in paragraph 8C, excluding the 7 legislations and subsidiary legislations through which the Safeguarding National Security Bill. We will, through different ways, adapt the laws. I, in the capacity of Secretary of Justice, will promote the Statute Law Miscellaneous Provisions Bill 2024, which is also known as the Omnibus Bill. The other ones will, in the legal year 2023-2024, the draft will be introduced. We have actually submitted the relevant information to the Secretariat in order to work out a pragmatic timetable. The Secretariat of LRC has taken into account the complexity and interrelation, categorized the legislations and subsidiary legislation into different groups. Please refer to paragraph 7 of the paper. In Annex B, we have provided a chart. We seek to, through a simple way, show the number of pieces of legislation examined under the adaptation exercise by categories so that the panel has a general idea of our work. This is in the form of a bar chart, and it facilitates members' understanding of our exercise. We should not underestimate the difficulties of the adaptation exercise. For some of the legislations, we have to further study them in order to work out a timetable. I'd like to talk about the challenges. For different legislations and subsidiary legislations, they may be interrelated, and there may be cross-references with other legislations and ordinances. We have to make adaptation amendments for all these legislations. So we have to ensure consistencies across all these legislations. We have to ensure we can reflect the decision of MPCSC in accordance with Article 160 of the Basic Law. For some of the legislations, before we can finalize on the adaptation provisions, the relevant bureau or more than one bureaus will have to make suggestions, and we have to take into account their suggestions. So after we have got the relevant legal advice, we can then finalize on the adaptation provisions. There may be criminal laws and civil laws involved, and there may be constitutional laws, international laws that are involved. When we formulate policies that involve legal issues, we cannot undermine the level of complexity. Also, for adaptation of laws, we have to consult the central authorities and the relevant bodies and groups. So far, we have consulted the central authorities or are currently consulting the central authorities on some of the proposed adaptation. The Secretariat will continue to consult the relevant bodies. We have to give due regard to the feedback received and follow up on those feedback. For subsidiary legislations that involve references like Your Majesty and Crown, we cannot mechanically duplicate the references made in other legislations. It is not a mechanical copy and paste exercise. I ask for members' understanding on our exercise. In the process of our adaptation exercise, we have to consider the original policy intent. We have to see whether the amendment would alter our policy intent. Also, we have to carefully consider whether it is in line with the one country, two systems principle. Also, we have to accurately reflect the decision of the Standing Committee of the MPC in accordance with Article 160 of the Basic Law. We also have to ensure that the common law as well as the adaptation provisions are consistent with each other. Also, we have to ensure that there are no issues as we implement the laws adapted. The bureaus responsible will have to consider technical issues as well as other issues. We have to consult the relevant legal advisors, and when it involves the power of central authorities, we have to fully consult the central authorities to finalize the adaptation of provisions. In the process, the Secretariat of LRC will have to keep in close communication with the central authorities to ensure that the adaptation exercise is heading towards the right direction. We'll also have to ensure that all complex and intricate matters can be dealt with. We'll continue to adopt the approach of handling the difficult issues, the simple issues first before the difficult ones. Apart from the 8 legislations that have already been appealed since last July 2023, there are at least 13 legislations and subsidiary legislations which have been identified, and they will be repealed through the Statute Law Miscellaneous Provisions Bill 2024. The Secretariat of LRC will continue to monitor the progress of our exercise, and we will make a report to this panel once every 6 months. I hope members can understand that as we give a report on our progress, the Secretariat of LRC cannot preempt other bureaus or parties. We are happy to take questions. I thank Secretary of Justice for the introduction. Members who would like to speak, please press the button. I'd like to now invite Mr. Martin Wong from the Hong Kong Bar Association to speak on this topic. Please try to finish your speech in 5 minutes. Thank you, Chairman. The Hong Kong Bar Association, in this regard, would just like to make the following few points. First, like the stance we have made in the previous meetings, this systematic review is a large-scale work. It requires a lot of manpower and resources. So we are happy to see that progresses have been made. We also see that the work made has been very comprehensive, and there are further amendments that have to be made to the law. And we're happy to see progresses in this regard. This is an arduous task which requires lots of resources. I see from the administration's paper that in the future, if more resources are needed, the LRC Secretariat will ask for resources. And the Hong Kong Bar Association would like to give our support to that because this is an arduous task. Thank you, Mr. Wong. Now I'd like to invite the President of the Law Society of Hong Kong, Mr. C.M. Chen, to speak. 5 minutes, please. Thank you, Chairman. Members, good afternoon. Before I speak, I'd like to declare that I'm a member of the LRC. Now I speak on behalf of the Law Society of Hong Kong. The Law Society welcomes and supports the LRC to make regular update on the systematic review of statutory laws of Hong Kong. This includes adaptation of laws, consolidation of laws, and repeal of obsolete laws. The Law Society thinks that the LRC's works has been meaningful in terms of keeping the laws of Hong Kong up to date. We see that the focus of today's report is on the adaptation of laws. We see that so far 101 pieces of legislation have been reviewed by the LRC in terms of adaptation of laws, and we'd like to express our gratitude on that. We have some suggestions. First, for periodical payments for future pecuniary loss in personal injury cases. And second, for children proceedings bracket parental responsibility bill. And third, corporate rescue bill. I mentioned these 3 pieces of legislation because our members have views on those.
For these 3 pieces of legislation or bills, Well, the LLC have been examining the issues for years. Understand this is not the responsibility of the DOJ, it's the responsibility of relevant policy bureaus. But we do think that we should take forward the relevant adaptation for these three pieces. We have already issued our comments on the 2021, and the task force has also issued a report. We hope that the recommendations can be taken forward. For example, the children parental responsibility bill is the subject of an LLC report some time ago, but so far we haven't seen anything in taking them forward. It's important on the issue of parental responsibility and also to implement the children's interest first principle. The public consultation has already been completed. In 2018, the SAR government already make a recommendation to the Welfare Services Panel that the bill will not be issued in that year. So far, we haven't seen a bill to this effect. We hope that since we highly appreciate the LLC's effort in carrying out the reforms, we should see to it that it's completed early. As for the corporate rescue bill, our members and the commercial business sector have been asking for this for many years. This is once again coming from a report of LLC back in 2018, and in 2022-23 financial year, the Law Society reiterated our request to have this new law on corporate rescue, which will be instrumental in enhancing our competitive edge. The last time the LLC mentioned this is November 2020, and things have changed a lot since then. I hope the government would take forward this corporate rescue bill as soon as possible, which will be in line with the aspirations of my sector. 4 members would like to speak: Mr. Tang Fei, Ms. Maggie Chen, Ms. Carmen Kan, and Mr. Holden Chow. Mr. Tang Fei, I have a simple question on adaptation. Well, it's something of course. As a layman, I'm a bit curious that 25 years have passed since 1997. It's already past the halfway milestone of the 50 years. Earlier, when we enacted the Article 23 legislation, the Bills Committee to discuss issues related to the central authorities. And we issue a statement to define what it means. So why is it that we have taken more than 25 years to do the adaptation comprehensively? Well, in some English-speaking jurisdictions, there is the standard procedure to use simple English to take the place of outdated English usage. I'm not just talking about Latin. So we should do something to simplify the wording of our laws. We have civil law, we have criminal laws. Of course, things have to be settled through this council before we enacted the amendments. And if we have only got LLC recommendations, will the DOJ refrain from quoting or referencing to these soon to be deleted or amended laws, especially in civil cases would you refrain from invoking such soon to be amended or the deleted laws? First of all, well, to many people, more than 20 years have passed, and why it has taken so long? As I've explained in the paper, there are many issues to be addressed, and the more we look, the more we can identify. If you look at Annex B, last time we talked about 81 pieces, and now we have discovered there should be 101 pieces. So there are many pieces of legislation that we need to address. Sometimes they are not easy to detect. Some people think that if it's the term of Her Majesty, we can just replace it, right? But by what? It's not as easy as that. It's not just deleting an old term. So we have to look at the intent of the original term. Is it about power or privilege? And we need to look at the original policy intent. That's not something that the LRC can do on its own. We need to liaise with the policy bureaus. Repealing such terms is easy, but replacing them with appropriate terms is not. For example, I've talked about central authorities. Mr. Tang is right that in the Article 23 legislation, we spend a lot of time on how to come up with a term to describe central authorities. And we are grateful for the guidance provided by the CPG. It's not easy to be accurate and precise. And sometimes we will involve foreign entities. For example, marine shipping, we used to invoke British standards, and we don't have a set of Hong Kong standards. So what should take the place of the original standards? We need to consider the relevant issues thoroughly. So that's why we go for the easier, simple ones. And this time through the omnibus bill, we are going to adapt 40 pieces of legislation. I hope members of the public will understand why it has taken so long. Sometimes when we take forward an amendment bill, we take the opportunity to simplify, to modernize the language. Whether we are talking about the law in English or in Chinese, we want to go for simple and easy to understand Chinese and English for our laws. On the question of obsolete laws, well, if they are not repealed, obsolete laws are still laws. Sometimes it's about the wording used or terms used. In Cap 1, there are provisions to interpret certain terms before these laws are repealed. And secondly, the court will also make reference to Hong Kong's circumstances in doing some adaptation. We need to maintain these terms, otherwise there will be a vacuum in our legal system. Ms. Maggie Chan. Thank you, Chairman. The systematic review of statutory laws is a grand scheme of work. And the Secretary and the LRC has identified 101 pieces of legislation. You added another 20 pieces last year. Are you going to identify even more in the coming years? Are we going to see an increasing bigger number of pieces of legislation that require adaptation? I can see that 34 pieces have been identified without setting your mind on the way forward. For example, you go for these simple ones before tackling the difficult ones. But what ordinances or laws are more complicated in your view? And for such laws, identified as complicated ones. Do you have a timetable for dealing with them? The member is correct. If you look at Annex B, you can see the number has gone up from 74 to 81 to 101. I hope if we identify more and more, then we will miss less and less. But I cannot rule out the possibility that there will be more uncovered. But the principle is to find out as many as possible. For the 34, they will be dealt with under the omnibus bill. Another 40, for which there's no definite solution. I don't have time to deal with all of them one by one, but the policy bureaus must give us some instructions first. We have to ask them to indicate their policy intent, especially marine laws. I'm impressed by some of them. Then when we want to find a substitution for British standards, it's not that easy. And for some involving the central authorities, we are in communication with the relevant departments of the CPG. There are regular meetings. We'll sit down and discuss with them one by one. And the central authorities may also need time to understand the original policy intent of these pre-reunification laws. And they have to consider whether there will be certain obligations to be shouldered by the central authorities representatives in Hong Kong. So the timing is not entirely in our hands. But we would like to do as many as possible. But I would be irresponsible to say that we can definitely deal with all of them within a certain time frame. For some issues, some pieces of legislation, we can say certainly we would be able to deal with it before, say, the summer recess. But for others, I can only say that we will come back to you as soon as we are ready. Ms. Carmen Can. Thank you, Chairman. I'm grateful that the DOJ has given us a bar chart in Annex B. This is in response to my previous request to show something in a figure or in a chart to show the progress. So we can understand now that compared with the previous report 6 months ago, we have seen good progress. And we have seen also there are 34 indicated by the gray bar, and that it will be dealt with by the omnibus bill. But I want to make 2 recommendations here. First, in paragraph 11 and paragraph 12, the DOJ has indicated that the amendments or adaptations, either to revise or introduce new laws, will be carried out by the policy bureaus. I would like the DOJ to respond to the 3 pieces of legislation or 3 pieces of proposed legislation referred to by the Law Society. And from my personal observation, sometimes a bill is the responsibility of more than one policy bureau. Very often, the policy bureau would amend the relevant parts when they introduce a bill to carry out certain adaptations, such as to adapt in terms like Her Majesty or Crown. But for other provisions not covered by this bill, they would await the decision of another policy bureau. And that's why we have a situation whereby the situation indicated by the second note of the bar chart in Annex B is that there could be a situation whereby even if a bill is presented, it's only partial adaptation. So my first proposal is that we should discontinue such a practice. If a policy bureau has identified that other provisions involving another policy bureau will have to be adapted, perhaps they should invite that other policy bureau to introduce to this council how it proposes to take matters forward so that this council understand what is to be done in our consideration of the bill. And also, I would like to seek a response from the DOJ. For example, Note 12. Sometimes other legislation will be involved. There are 34 pieces of legislation which cannot be dealt with by the omnibus bill this time. My question is why?
Secretary, let me take the first question. I agree with Ms. Carmen Khan's observation. We should not make piecemeal enactment. We should do it in one go. This is where the Secretariat of LRC comes into play. The LRC serves as a coordinator among different policy bureaus. We consult all the policy bureaus in one go and we strive to complete the adaptation provisions altogether. We try to avoid piecemeal enactment because this would be time-consuming. Some of the questions have to do with adaptation of laws and some do not. On the bill about periodic payment, I believe this has nothing to do with adaptation of laws, but this is under the purview of the LRC. I don't mind taking the opportunity now to talk about this. We have a working group with policy bureaus to work on this bill, and we are duty-bound to work on this, and we will continue to follow up on this bill or legislation. I'm quite familiar with the legislation, so I do understand the need to amend the law. On the parent and child corporate rescue bill, we require the relevant policy bureau to undertake the work and take the lead to do so, because the bureau will consider whether it is necessary to make the adaptation. Say for corporate rescue bill, it is under the purview of FSTB, and I will follow up on this. For the other questions, let me see if Mr. Martin Wong can supplement. Mr. Wong. With the coordination of the LRC Secretariat, different policy bureaus are responsible for different legislations, and the Secretariat takes the lead of the adaptation work of more than one piece of legislation. Secretary mentioned that two pieces of legislations that have to do with the family court have been dealt with. One is about the matrimonial costs law, and the other one is about parent and child ordinance. And we have completed the adaptation exercise for these ordinances. This is one of the examples. the Development Bureau mentioned about one ordinance, and the ordinance have to do with town planning, and it is to streamline the relevant procedure. And we've also dealt with the adaptation of other ordinances concerning road works through this adaptation. Some bureaus may have put forward ordinances that have to be adapted, but they did not deal with the areas concerning other policy bureaus. And this would not push back on the issues that have yet to be push back on the process, because there are issues that have yet to be dealt with by other policy bureaus, and that's why we adopt the approach of dealing with simple issues before the difficult ones. As for footnote 12, it is not the case that we did not deal with these legislations. We mentioned in Annex B that there are 34 pieces of legislations, together with CAP 311 and CAP 358. The adaptation of, if we take into account the adaptation of these two ordinances, there will be an additional 30 some legislations that would be included. We don't want to see a surge in number from 101 to 130 some pieces of legislations because of that particular ordinance. On the adaptation of the two ordinances that have to do with air pollution, we are planning to include them into the omnibus bill. So there's no delay in the process. Ms. Khan, I thought the 30-some pieces of subsidiary legislations are not going to be adapted, but now I understand that they will be dealt with through the omnibus bill. Perhaps we can name and praise the bureaus that have been doing well in this area, instead of name and shame. Mr. Holden Chow, I'd like to thank DOJ and the team for taking forward the adaptation exercise. I believe it is a very complicated process, and I'd like to thank the Secretary for attending this meeting today to explain to us about the work. Riding on what the Secretary has said, I have a couple of questions. I understand that some of the laws will have to be amended, and I understand that we have to study the original intent of having a particular piece of legislation. For instance, why should we include the wording like Her Majesty in the provision? As the Secretary said, we have to look at the original legislative intent. My question is this: while you take forward the adaptation exercise, would you look at whether there will be negative impacts or misunderstandings if certain wording or certain provisions are kept in the way they are now? If there is a negative impact, of course you'll have to first deal with those legislations first. If not, you may deal with them later. I wonder if this is the approach that you are taking now. Say, for some of the legislations or provisions, even if you do not make any amendments to them, there won't be any actual impacts to our laws. So this is what I want to know. Secretary, I'd like to explain the rationale behind our work. Crown Proceeding Ordinance is one that is very familiar to the legal practitioners. Crown can mean many things. It can mean obligation, it can mean responsibility in different contexts. We have to first study the legislative intent of the relevant provisions. It is a piece of legislation with a long history, so we have to first study the legislative intent. So after we've learned about the legislative intent, we ask ourselves this question. Does the original legislative intent fit into the current situation, or is in line with the current situation in Hong Kong? We may have to amend the provision. So it is not just about whether we should make the amendment or not, because it has to do with our policy intent. There are pros and cons to making amendments or not, and therefore we have to talk to the relevant policy bureau. And if the central authorities are involved, it would be more complex, because we have to see whether the amendment would be in the interest of the central authorities. For instance, should we change the wording to central authorities or central bodies? We have to take into consideration the actual situation in Hong Kong. So after we have taken all these into considerations, we have to decide whether we should retain the relevant provision or whether we should amend it. If we amend it, then we have to talk to the central authorities or the relevant policy bureau on how we should introduce the amendment. So for every single provision, we have to go through this thinking process. This is a lot more challenging than we think. Any follow-up questions? Yes, Ms. Maggie Chan speaking for the second round. I thank the Secretary for the detailed explanation. The Secretary also mentioned about the challenges that we are facing. Since the 1st of July 1997, there is an ordinance about the return of Hong Kong to the motherland, and one of the sections is interpreted according to Schedule 8 to the Interpretation and General Clauses Ordinance. There is mention about how to interpret wording like Her Majesty and references like the royal. And there is also mention about what these references or how these references are going to influence Hong Kong. There are some 22 points set out here. Would this be conducive to the deliberation of the policy bureaus? Secretary, I'll give a brief response and then I'll ask Mr. Wong to elaborate. So this has to do with the interpretation of MPCSC in accordance with Article 160 of the Basic Law. It takes time to make an interpretation. However, before we can complete the interpretation, we need to give a guideline to the court. But this is not the ultimate solution. At this stage, we have to have a set of guidelines that we can abide by.
Because you should at least tell people what's the temporary provision for substituting the term, say, Her Majesty. But that particular system will not provide the final answer that will only come after adaptation. So before we have the final solution of adaptation that would provide some kind of aid to us, that's not a final solution, but it would provide a temporary solution so as to improve the impressions of the reader. Secretary, Mr. Wong? Well, I make no claim to being an expert, but I do understand that there was such a arrangement. Actually, in Schedule 8 and then Schedule 9 of Cap 1, that's the result of the decision of MPCSC on the 23rd of February 1997 in respect of Basic Law Article 160, and that would become part of the SAR law on how to interpret certain terms. This is an important piece of legal instrument on how we can come up with interpretation. But it's not just mere substitution of terms or wording. I've actually quoted the example of matrimonial clauses. In one of the provisions is used Her Majesty, and in another the term Crown is used. We need to conduct a research into the background information back to the 1920s. And we were fortunate that during the Japanese occupation, such records were not lost. So in the adaptation process, we carry out the process rather smoothly. And that's another bill. And on the issue of e-penalty ticket for traffic offenses. That's related to Mr. Tang Fei's point about the use of plain language. We have introduced a new term concerning official vehicles. That would cover not just vehicles owned by the SAR government, but also representative offices of the central authorities in Hong Kong. It's not ideal to just rely on Schedule 8, because for fixed penalty offenses, usually the driver is not in the vehicle. If a ticket is issued against a government vehicle, there's no point in asking the government to pay to the Treasury the fine required. So in the new law on e-penalty tickets, we handled this one. And in the two bills that are being handled by this council, this particular problem will be resolved. And in the 2024 omnibus bill, the statute law miscellaneous provisions bill, there will be some provisions to be retained. In those provisions, the relevant Schedule 8 interpretation will also be removed in respect of those provisions that we are going to keep in the new law. So we will always make reference to Schedule 8 and Schedule 9, and if the reference is no longer necessary, we would repeal it in the adaptation bill. All right, Mr. Ho Chun Chow would like to speak in the second round. I'll draw a line here because we have got another important item under agenda item 4. I'm very honored to be a member of the Article 23 Legislation Bills Committee, during which we did find out that in one of the miscellaneous amendment bills, we follow the practice of England Law Reform Commission. And even if this, we consider a provision on whether there will be negative impact if we say that we must refer to the English system, because there are already court judgments saying that we should not follow the English system blindly. Because we are a common law jurisdiction, we can refer to other common law jurisdictions and the precedent. The government has assured us that this will be done. This will be the way forward. So even if the provision is kept, there will be no substantive impact. And secondly, we consider how to amend it. And if we delete the reference to England or English system, and we say it's a common law practice, then what jurisdictions are we talking about? So that's my personal experience, that in considering how we can replace a term or substitute a term with a new one, it's not a simple switching from one to another. I'm grateful to the Secretary and the Commission for doing a good job. I understand that in the Article 23 legislation, we have covered many similar issues. Any response from the Secretary? Chairman, you may remember that it was about, the point is about criminal procedure. And it states that by default, we would refer to the English practice. But the courts are saying that it's not mandatory. But should we delete this reference because we are not really content that we should get rid of such a catch-all fallback position? So that's how we consider things in that Bills Committee. All right, that wraps up this item. We now move on to item number 4. Updates on cooperation with international legal and dispute resolution bodies and attracting their presence in or carrying out of activities in Hong Kong. International bodies and organizations other than the International Organization for Mediation. And the paper is LC paper number CB4334/2024, bracket 05. This is a paper provided by the administration. Members who wish to speak may now press the button. I'd like to welcome the Secretary for Justice and his team for their attendance. Secretary for Justice, please walk us through the paper. Chairman, members, to improve Hong Kong's profile and raising Hong Kong's international profile, promoting the strength and opportunities of legal and dispute resolution services in Hong Kong. It's been DOJ's ongoing policy to strengthen cooperation with renowned international bodies, attracting their presence or carrying out our activities in Hong Kong. On the 23rd of January, we have already briefed members on the case involving the IOM. And now I will be talking about the latest progress in respect of other international bodies. There are 5 that I would like to cover. First, International Institute for the Unification of Private Law. We have signed a MOU with the Institute, UNIDROIT Unit Trove, on the 27th of May 2022, and the Deputy Secretary for Justice visited Rome, Italy on the 6th of March 2023, and met with the Secretary General to discuss more collaboration opportunities. And during we would be co-organizing with the Unit Trove the Second Asian Pacific Private International Law Summit. We are now cooperating with the Secretariat of Unit Trove that we would strive to submit an information paper on the establishment of the Mediation Office in Hong Kong in June 2024. This would facilitate the work of the Unit Trove in Hong Kong and also in enhancing our status as a legal and dispute resolution center in Hong Kong. The second body is the Hugh Convention, the Hugh Conference on Private International Law, IHCCH. It has set up an Asian office, regional office in Hong Kong, and we have been. It has been in cooperation with the DOJ in organizing activities on capacity building, covering many states, many of them Belt and Road countries, and we co-hosted the HCCH Asia Pacific 2023 in September 2023, and more than 20 jurisdictions and speakers attended the conference, and the practitioners, government officials, and legal practitioners participated either physically or through online provisions. And we have been working with the UN Commission on International Trade Law, and with our close cooperation with UCITRO. The 5th UCITRO Asia Pacific Judicial Summit was successfully held last year in Hong Kong as part of Hong Kong Legal Week 2023. The event attracted a record high number of participants, over 750 registrants from over 50 jurisdictions attending online and in person. Among them, around 50 judges and officials from 22 jurisdictions attended the event. And with the support of Asian Development Bank, this is the first time we provide this SI in the language of Timor-Leste, showcasing the importance of this capacity building event for participants from the regions. And we have also conducted a hybrid meeting of Inclusive Global Legal Innovation Platform on online dispute resolution to explore the latest development and potential issues with many participants. The fourth organization is Asian African Legal Consultative Organization, AALCO. Following the successful hosting of the 59th annual session of AALCO and also the opening of the AALCO Hong Kong Regional Arbitration Center in 2023, we have been strengthening cooperation with AALCO. We have participated in the 6th training session of the China AAL Exchange and Regional Program. We have been sponsoring the Hong Kong part of the program since 2017. The 6 training sessions was attended by the 55 member states from ASEAN countries, League of Arab States and the African Union. And from the 5th to 6th of December 2023, we hosted the 3rd AALCO Annual Arbitration Forum in Hong Kong. We provided financial support to the forum. The event attracted more than 30 countries' representatives, of government officials, and also observers from international organizations, altogether 3,000 participants. And it was a teleclass to a even wider participants. And this has greatly enhanced the visibility of the recently established AALCO Hong Kong centers, and also provide the provision of service to member states, investors, and business community for resolving disputes, and also is It has contributed to the capacity building initiative of DOJ in the field of dispute resolution. The fifth organization is the Hague Academy of International Law. And the first edition of the Hague Academy of International Law's advanced course was held in Hong Kong from the 11th to 15th December 23. Over many eminent speakers participated using the course to exchange experience and knowledge. And this is a unique addition as part of our efforts to enhance Hong Kong as a leading center for international legal services and capacity building. And also in line with the 2023 policy address, it plays a pivotal role in nurturing a pool of talents in Hong Kong. And we'll continue to strengthen cooperation with international legal dispute resolution bodies in taking forward the policy initiative in developing Hong Kong as an international legal and dispute resolutions. The participants have given us very positive feedbacks. The DOJ will continue to cooperate with such international organizations in promoting our opportunities and experience and tell a good story of Hong Kong's strength and rule of law. This will be in support of the CAE's 2023 policy address, including the establishment of the Hong Kong International Legal Talents Training Academy. The academy would take forward such course, and there will be within 2023 a dedicated new office and expert committee to support the latest development. So this is my report, Mr. Chairman.
Now I invite Mr. Martin Wong, Deputy Honorary Secretary of the Hong Kong Bar Association, to speak. Thank you, Chairman. The Hong Kong Bar Association has a very simple remark. We see that the DOJ has done a lot of work in this regard, and results have been achieved, and all this work done by DOJ helps facilitate the role of Hong Kong in trade and also in financial services. I hope the DOJ will keep up with this effort. Apart from maintaining its current relationship with international bodies and organizations, it can open up more ties with international organizations. If the DOJ needs our support, we'll definitely give our full support. Thank you. Now I'll invite representatives from the Law Society of Hong Kong to speak. Thank you, Chairman. The Law Society of Hong Kong supports Hong Kong's status as an international legal and dispute resolution services center. We see that the old Wan Chai police station has been converted into the center for the legal and dispute resolution center. We hope that we can work with the International Organization for Mediation. We also note that the DOJ has been working with international bodies and organizations other than the International Organization for Mediation. I will now invite my colleagues to speak.
Government's initiatives to promote Hong Kong's legal and dispute resolution services to countries and regions in the Middle East, e.g. Saudi Arabia. We consider that in implementing this initiative, it is essential for dispute resolution lawyers in Hong Kong to equip themselves with the specialist knowledge in resolving disputes arising from Islamic culture regions. This is important to clients from the Middle East. We appreciate the government's efforts on strengthening the collaboration with Asian African Legal Consultative Organization and also support rendered to the China ALCO Exchange and Research Program on International Law. ALCO is the only international legal consultative organization in the Asian African region. The Society is pleased to see that ALCO has chosen to establish its sixth and latest regional arbitration center in Hong Kong. These arbitration centers function as international institutions to promote international commercial arbitration in the Asian African regions and provide for international arbitrations. ALCO also assists in member states in the appointment of arbitrators and other matters related to arbitration practice, including training of arbitrators in relation to arbitration practices across different jurisdictions in Asia and Africa. These are all conducive to equipping dispute resolution lawyers in Hong Kong with the specialist knowledge for them to provide services in the Middle East countries and regions. The Law Society supports and participated in the third ALCO Annual Arbitration Forum organized by ALCO and the ALCO Hong Kong Regional Arbitration Center in December 2023. At the forum, the President of the Law Society has spoken on dispute resolution in Asia and Africa, the way forward. He shared his views on international cross-border arbitration. The Law Society will continue to establish and enhance our working relationship with ALCO and other international dispute resolution institutes and promote dispute resolution for the Islamic world. Thank you, Chairman.
Now, Mr. Hyun Wong. Thank you, Chairman. I'd like to speak about the development of dispute resolution services in Hong Kong. Apart from what our Vice President spoke about the Islamic market, I think Hong Kong should also tap into other potential markets, including Russia and also Central Asia and countries in South America. We should promote our dispute resolution services to all these places. Also, we should also tap into other areas, for instance, virtual assets, family offices, IP, and also wealth management. There's been a long history of development in these areas in Hong Kong. We should also tap into the entertainment businesses. We understand that the DOJ strives to develop Hong Kong as a platform for IP trading. However, we have yet to hear from DOJ about its progress in recent months. The Bar Association and the Law Society is giving our support on tapping into the sports industries. These industries have great potentials, and we can offer arbitration and dispute resolution services to all these industries. In this connection, we think the SAR government can take the initiative to reach out to mainland as well as international organizations so that we can be the pioneer in this area around the world. Also, the SAR government should also work with renowned organizations in the mainland to provide dispute resolution service as well as arbitration service with them. These renowned organizations, they have their strengths in different areas. They also have their client base. We hope that they can provide arbitration services in Hong Kong or work with the arbitration industry in Hong Kong or conduct exchange with the arbitration industry. We can tap into their knowledge and expertise, and this will help enhance the quality of our services. The Law Society hope that under the leadership of the central authorities, the SAR government can continue the success of holding international events in Hong Kong and attract the presence of international bodies in Hong Kong to support the strategy of the National 14th Five-Year Plan and the Greater Bay Area Development Plan to develop ourselves as an international legal and dispute resolution services center. Now I'll open the floor to members for questions. 3 members have pressed the button to speak. They are Mr. Tang Fei, Ms. Carmen Khan, and Mr. Holden Chow. Mr. Tang Fei. Thank you, Chairman. I have 2 questions. I'm happy to see that there are so many collaboration projects initiated by the DOJ to attract the presence of international organizations in Hong Kong. There are 2 major objectives. First is to attract international organizations to establish presence in Hong Kong. Second, to hold activities and events in Hong Kong. From the financial perspective, would that exert financial burden to the DOJ or SAR government, and that's the DOJ will have to put aside more budget for this. Not to mention setting up offices. For instance, the International Mediation Organization. Well, some civil servants may have to be deployed to work for the setting up of office of the International Organization for Mediation, and this take up the resources of the SAR government. Can the Secretary tell us whether there would be a need to open up new positions or set aside extra budget for all these goals? My second question. Well, given the complex geopolitical tension, Hong Kong, as a center of rule of law with its advantages, we can play an important role. This is because rule of law is an important advantage enjoyed by Hong Kong. We have been collaborating with all these international organizations and bodies as we attract their presence or as we invite them to carry out activities in Hong Kong. Does the SAR government encounter any challenges? Has it seen any obstacles as it tries to attract the presence of international organizations? I'm not sure if the Secretary is in the position to answer this. I'll take some of the questions and then I'll ask Mr. Deng to elaborate. There are two aspects to our work. First, we attract international organizations to establish their presence in Hong Kong. The HCCH is one of the examples. We have to, of course, offer financial support to these organizations. When you work with an organization, you would want to negotiate with them. They'll have to show some commitment and contribution. And sometimes we consult our foreign affairs ministry, as we take forward the negotiation with international organizations. On manpower, now mediation is complicated. We have staff from the DOJ as well as we ask lawyers, including solicitors and counsels from outside of DOJ to visit The Hague. And this is to facilitate exchanges. We have been met with different challenges, but so far we've got positive feedback from most of these international organizations that we are working with. Well, the geopolitical landscape is complicated, but at the same time, legal practitioners from different countries, they are sensible and they understand the situation in Hong Kong. We need all these collaborative experiences to promote Hong Kong, but at the same time, we do not underestimate the challenges that we may face. Ms. Carmen Khan, 4 minutes, questions and answers inclusive. Thank you, Chairman. Well, Hong Kong is international, and so the work being taken forward by the DOJ is important. And I give my support to the cooperation of DOJ with all these international organizations. I think the DOJ should keep up with its efforts This includes continuing to work with the ELCO and attract all these organizations to carry out activities in Hong Kong. I try to take part in all these events and activities held by the international bodies and organizations. I think the exchanges between DOJ and these international organizations will bring about positive impact to the city.
I have a question about the issue raised in paragraph 25, the training, the international legal talents training. There will be an application before the ESC on the creation of posts to support this. Can you say something about how we are going to strengthen the exchange with such an international organization? This is part of the proposal submitted to the ESC. On the question of the Hong Kong International Legal Talents Training Academy, well, this is one of the major initiatives this year. This is under preparation. We're going to set up a dedicated new office and an expert committee. We are grateful to this council for your support. Also, there will be a meeting next Wednesday or Wednesday the following week. Because such a program requires manpower and a lot of lobbying and coordination is required to implement this. Inevitably, there will be the need to coordinate with different parties. For example, how do we recruit the trainers? Some of the trainers may be readily available with the right expertise from other international organizations, so we strengthen the cooperation with these organizations so that we can benefit more participants or trainees. So we do hope that the council can support in terms of resources. Thank you for your question, Ms. Khan. I would just like to add another point. In offering training courses, you should do what Mr. Wong of the Law Society has said, that we should involve arbitration academies or organizations in the mainland so that you can combine both training and practice in the work of the academy. So that's just a comment. Thank you. Mr. Houghton Chow, Chairman, I'm also going to make a suggestion here. I'm grateful for the administration for promoting Hong Kong's status as a legal and dispute resolution services center. It's very important that we have the setting up of an office by the International Organization for Mediation. Well, I did participate in past legal week activities, and I had the opportunity to communicate with international legal experts. So here, I would like to make a suggestion. Recently, I understand that in the business sector in some Asian countries have been looking at virtual asset and the Web 3.0 sector. These countries are very interested in the establishment of trading platforms in Hong Kong for such virtual asset types. So in the future, they would like to involve in our trading platform, and as a result, there will be the need for legal services and sometimes also arbitration services. So, Mr. Lam, if these countries have shown interest on fintech, Web 3.0, and virtual asset trading in Hong Kong, if they're interested, perhaps we can also invest something to cooperate with these organizations. I understand you are in communication with them. So apart from the legal week activities, perhaps explore other spheres because in the long run, if more and more parties are showing interest in Hong Kong's relevant development, we should tie in with the provision of legal services. Well, this is a new sphere. Countries over the world are all in the development stage. So perhaps if we invest more, then we'll be able to entrench or enhance our status. If we are talking about such a development, it's not just about legal services. And these services are interrelated. If we want to develop virtual asset, green finance, etc., then the parties will need to consider risk management and the availability of legal services. So we need to offer the full package and showcase our advantages. And the ASEAN countries will be the focus of the DOJ. Later this year, I would like to invite fellow practitioners to attend some events in the Southeast Asian countries on relevant developments. And we'll not just be talking about legal services, but also the fintech and other infrastructure. We are in discussion with some policy bureaus already. For example, there's a dedicated task force on Belt and Road countries, and the promotion will not just be on legal services, but that will be a full package of what is available in Hong Kong. Members, further questions? If not, then that wraps up this item. Item 5, AOB, any other business. If there's nothing under AOB, then meeting's adjourned. Thank you.